So the employer has another defense in an unjust dismissal case. The employer can assert that the job held by the individual was discontinued due to economic reasons. It's not as easy as you might think for the employer to win on this case. The general thrust of this is that the employer has to be acting in good faith. If it's found the employer is acting in bad faith, then the employee will have a remedy for the unjust dismissal complaint. So let's break it down in terms of what the employer has to show to succeed in this defense. Again, if the employer succeeds in this defense, it doesn't mean there's no remedy. The employee can sue civilly for wrongful dismissal. There may be a human rights complaint, but we'll discuss that later. So this only relates to the unjust dismissal remedy under the Canada Labor Code. So the employer has to pass two tests to win this defense. First of all, it has to show there's a genuine economic reason to justify the layoff. And secondly, it has to show some evidence as to why the person or persons selected are the persons being chosen for the layoff. So if the employer does not show particularly the second reason, then there's going to be a remedy. It all is underpinned by the requirement that the employer has to show it's acting in good faith. There have been cases where the employer has shown that, yeah, it was a reasoned economic decision. There was problems economically, financially, and there was a need to cut back, but it did not show why this individual or individuals were selected for the layoff. So it's a difficult burden for the employer to show. It's not as easy as you might think. Also, if there's been any history of disputes with this person. So if the person has shown himself to be a difficult employee in the past, that may also add another layer of context to the case. I had one case myself when I was in practice where the employee had filed an unjust dismissal complaint some 4 or 5 years earlier, succeeded in getting his job back, and the employer was really out just to get him and terminate his employment under the guise of it being redundant. The employer did not meet that test, and the case succeeded. And in that case, the employee, I think he was around 59, 60 when he was fired. He recovered 5 years paid to his expected retirement date. So when this remedy exists, it's very powerful. Again, it's not like wrongful dismissal, which has a notional cap of notice. These remedies under the Canada Labor Code, human rights, statutory remedies generally, have a ticking time clock until the final disposition of the case, which creates a formidable lost income claim and sometimes reinstatement and sometimes compensation for the loss of reinstatement. So again, understand your remedy and choose it carefully. Good luck.